Hello, 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 and welcome. If this is your first time here, welcome back. If you're returning, my name is Ajako O. Brown Esquire, and today we are doing Thursday Thoughts. If you've never joined before, each week on Thursday I go live and provide my thoughts on questions that have been asked to me. Those questions are either posed on the various social media channels or they are from clients that have come through, friends, family members, however they come into my sphere. I take the time on Thursday to answer them or give my thoughts on them, hence the term Thursday Thoughts. So thanks for tuning in, and hopefully this will be useful to you. Tonight's question that we're going to provide our thoughts on are: what is the trademark office, the US Patent and Trademark Office, so talking about federal trademarks, looking for when they are looking at your trademark application? So someone asked the question, kind of, how do I even know if I'm going to get this mark? And this is someone who had gone ahead and used another service to go ahead and begin that process, but the service was not partnering with an attorney, so they were a little confused about what was going to happen next, or how do they know what was going to happen next, and what is the Patent and Trademark Office looking for. So I figured this was a good question because most people are probably wondering the same thing. So let's just start, I guess, with the beginning is your trademark or your service mark, which we use the terms interchangeable, are usually, generally speaking, it can be a sound, a word, a symbol, a phrase, a design, or some combination of all of those things that will identify your brand, your product, your services, and distinguish it from some other companies' products and services in the marketplace. So when you're talking about trademark, that's what we're talking about. Some mark, word, phrase, design, sound that distinguishes your brand from others in the marketplace. And we're talking about a registered trademark. In this aspect, we're talking about a federally registered trademark. So what are the US Patent and Trademark Office examiners looking for when they receive your application for a trademark registration? So first of all, let me just say that the patent and trademark examiners are attorneys, right? So they're looking at it from a legal perspective. And one of the first things that they're going to look at is what you are applying for actually covered by a trademark, or by the trademark rules and regulations, the Lanham Act, to be more specific. And that is because often when folks endeavor to do this without counsel, sometimes they may think that's something that is really covered under patent, or that's something that is really covered under copyright, or some other intellectual property avenue is eligible for trademark registration. So as first and foremost is they'll be looking to see is what you're actually applying for covered under what trademark protections are designed to cover in the United States. And then the next thing that they'll be looking for, is the owner of the mark, a United States resident, or a licensed United States attorney. So if you are domiciled, so your permanent residence where you live or reside is outside of the United States, or the business that will own the intellectual property, in the case if your business is going to be the owner of the mark, is registered outside of the United States. So wherever the business is registered is located, the business's domicile or permanent residence, then it is required that you have a licensed U.S. attorney to represent you through that trademark application process. So they'll be looking to see, are you the right person? Do you have the authority to submit this application? Either are you a licensed attorney, and that can be in any of the 50 states, any licensed attorney in good standing can represent you before the trademark office, or are you a United States citizen with whose domicile is within the United States? So that would probably be the next thing that they would be looking for. And I've not ever worked for them, I've just worked with them. So these are some of the reasons that people come to me when they've done it on their own or somewhere else and they've gotten a rejection and they need to overcome them. So these are some of the things that they would definitely be looking for. So we've said, is what you're applying for actually covered by trademark protection rules? And the second thing is, are you the right person? Do you have the authority to submit this application? Are you a United States citizen that's domiciled in the U.S., or the business is in the U.S., or do you have a United States attorney in good standing representing you? Then the next thing is the application, accurate? So very important that all the dates that they ask for, all of the information that you provide is truthful. You're swearing at the end, whoever signs it, that the information contained is accurate. And so that's what they'll be looking for to determine is what you said here actually true and factual. Make certain that in this area we're talking about that if you say you're using a mark in a certain class, which would be like avenue of business. So if you say I am a hairdresser and I am using my mark in hair salon services, then you need to be able to substantiate, like back that up. So they're looking to make sure that the class that you file in, the business that you say you're doing, you're actually doing. Hey, thank you for joining. The business that you say you're doing, you're actually doing. Make sure that both the dates that you say you've been using it from, the basis that you say that you're using it on. So the basis is generally speaking, either you're using it already or you intend to use it somewhere soon in the future. So that's the third thing that they'll be looking for, that you should be very careful about making sure that you have that information correct in your application. And then being able to provide that proof. So as I think I just said for number 3, the Patent and Trademark Office is looking to see that all the information is accurate. So the time that you started using it, the business name and address, the owner's name and address, the filing basis, and the class, like so what areas that your business operates in. And then you'll be asked to provide an example to prove that. And those are called specimens. So you need to be able to provide proof through your specimen that what you say you're doing, you're actually doing, especially if you're going on the filing on the basis of in use. So that's saying I'm already doing it, right? So you need to be able to provide an example or a specimen that says, yep, I'm in use and here's the proof. And then one of the biggest and the most important, I think, takeaways from this is number 5, will the mark cause confusion? Because primarily their main focus is to ensure that registering a mark doesn't create confusion in the marketplace. And by confusion, meaning is there already a brand out there that is using a same or similar term as you in the same or similar class? So if you are a talk show host and you have a slogan, but there's already a talk show host that has a very similar slogan, and that similarity is not necessarily just down to spelling, it's down to pronunciation, it's also down to compared on the terms of how do people interpret it. And I hope that makes sense. I'm trying to explain it specifically, because it's not just that it is exactly word for word, it's how it sounds when you say it. So sometimes people think that they can overcome the confusion aspect by maybe changing a letter or changing, the way that it's spelled, so it's not spelled properly, like using PH instead of F or something like that in a word. But if it comes out of your mouth and it sounds the same or similar to something that is already registered, then there's a high chance that will cause confusion and that you would get a rejection from the Patent and Trademark Examiner's office. So they're looking to avoid confusion. They would like to also, you would want them to avoid confusion. So you think of it this way: once you obtain your registered trademark, you don't want someone coming behind you or after you in the same or similar class using something quite from close to what you're already doing, so that the goodwill that you've created, maybe they can capitalize off of. So that kind of protects you as well once you've passed the hurdle of acquiring your registered trademark. So yeah, those are the main, I think, things to be considering of like, what are they thinking about when they're looking at your application. So when you get ready to do that process, using obviously I would recommend hiring counsel, but whatever process that you just decide to use, you should be aware that you need to be ready to provide proof, examples of how you're using your brand in the marketplace, with dates, samples, and all of those good things, specimens that back up what you've said, that your application is accurate, that your address and information represents a U.S. domicile, or that you have an attorney, and that that you've done your due diligence, or your counsel and team have done their due diligence to kind of ensure that you're not asking them to register a mark that's going to create confusion in the marketplace. Yeah, that is it. Hopefully this didn't go too long. I was trying to keep it brief. Sometimes I go over with my words and explanations. I hope that this was useful. Again, this tonight's topic was, what is the U.S. Patent and Trademark Office looking at when they're looking at your application and they decide whether they want to accept or reject your trademark registration. I will be saving this live, so thank you so much for joining. I'm glad that the awesome info. Thank you. I'm so glad it was useful. I hope that you'll come back next week and submit your questions. We'll be happy to share our thoughts on them each Thursday. Thank you so much and have a good night.